So our panel this afternoon to start is going to be on electronic monitoring and its use in bail hearings. Okay, this could be a little daunting when you're new, just understanding how it works, what the ministry will or won't do for your client, depending on their means, and how it actually functions and what courts are thinking about when it's being proposed as part of a bail hearing. So I'm going to turn it over to my panelists now, just one at a time, and ask everyone to take us through from their different perspectives. What is this technology? How useful is it or isn't? And when should it be used? So David, let me start with the Crown's office. Can you just step us through like the nuts and bolts of electronic monitoring? You know, is it available to anyone who requests it? What does your office consider? And can you sort of step us through what someone should expect if it's applied?
Sure. It is, youths are not eligible for the EM bracelet. That's the first thing to remember. I can tell you the Crown Policy Manual dictates that. Oh, I'm sorry.
There we go. No, it's on. It's on.
Is it on?
Yeah.
Okay. The Crown Policy Manual dictates that prosecutors shall seek detention in all cases involving firearms offenses, unless there are exceptional circumstances. And if there are exceptional circumstances, then the prosecutor should seek approval from the Crown Attorney or designate, usually a Deputy Crown Attorney, before consenting to or recommending any form of judicial release. Exceptional circumstances can include the strength of the plan of release. So we often see electronic monitoring proposed in firearms offenses. You will often have Crowns rely on cases like Gesso for the limitations around ankle monitoring. It, of course, doesn't prevent the commission of a further offense. It, of course, cannot prevent an accused from fleeing the jurisdiction. But Crowns like to see electronic monitoring in these types of cases because they do act as a significant deterrent. They will gather evidence, objective evidence of non-compliance, although as other courts have observed, they can't really tell you what the client is doing. They can only tell you where the client is. So where I see electronic monitoring being proposed is usually in cases where the accused has had several forms of release. They are alleged to have breached that release with a surety, and now we're bringing on a new surety or perhaps the same surety, but with electronic monitoring to really bolster the plan and maximize the safeguards offered to bring the risk to the public down to tolerable levels.
Okay. And is this, just so I understand, because I'm not in bail court as often anymore, is this simply available to any accused person, regardless of their personal financial means, or is there any kind of qualifying criteria that's applied to it? Do you know?
I don't know. I understand that it's free now for all accused. Cassandra, you may be in a better position to respond to that. Pre-COVID, clients did have to pay, but my understanding now from the Ministry of the Solicitor General is that it is available for free to everyone.
And if I may, I'll take over here because what we wanted to do is give a history of how we got to a place where electronic monitoring is more common. And so for those of you who are newer to practice, i.e. COVID or later, 2020 or later, this might come as a surprise to you, but the electronic monitoring wasn't always free. It was something that you had to pay for, and it was quite costly. It used to be about $700 just to get it installed, and then about $500 a month to have it monitor you. And so it really was reserved historically for murder, human trafficking, guns and drugs. The really serious cases is where you would see it, and typically in the superior court levels where bail had to be heard upstairs. We only then started using it as a free resource. The Solicitor of the Ontario, SolGen, what does that stand for again?
Solicitor General? Yep.
Yes, Solicitor General, thank you. SolGen started using it as a tool to help depopulate the jails in the middle of COVID because we needed to get people in mass communities away from each other, right? And so that's how it started as a free program, and it was welcome at the time. I was part of the talks about getting this started, and I was like, this is great. However, we as defense counsel, we were always looking to the future, as really any lawyer is, right? And thinking, okay, how could this be weaponized though? And the concern from an early time was, might we start over relying on this? Or might JP start over relying on this, or judges start over relying on this, or Crown start over relying on this? And unfortunately, we were correct that it probably has become over relied on now. And so it has become an easy tool for people to use in supplementing plans. Maybe you don't have a surety, but your client has somewhere to live. So then you want to suggest it in that case. But now this was talked about earlier, where trying to put to the JP the best plan possible in an effort to not leave any stone unturned so that your client can get bail on whatever they deem reasonable. I explain this to my associates and my articling students. I want to offer the Cadillac, but then tell them why they only want the Pinto, or they only need the Pinto, right? And so when I'm doing that, I'm telling them, like, here, we've done our GPS monitoring. Here, Recovery Sciences said that they can monitor. I've done that, but I'm only doing that because I want to make sure I've covered all my bases, not because I think you need that. And bail review law is hard, because if you don't offer everything right away and you weren't due diligence enough to do these things ahead of time, you can lose the material change argument on a bail review because you just didn't bother to do it, is how they look at it. But then at the bail stage proper, in first instance, if you offer it, it's almost like there for the grabbing, even if it wasn't probably necessary. If the JP otherwise might have released without it, but because you've offered it, they feel more comfortable. That doesn't mean it's reasonable. It just means that they're more comfortable, right? And so it really has become an issue in London, you know, because I probably was on the panel, and I happen to be the president there of our local association. So I was explaining to my colleagues how to use it and how to do it. And I'm still proud of that work of making sure that people understood how to do it so that we could get people out of jails, which were deemed unsafe at the time, right? But I can't help but think I'm part of the problem in that now all my colleagues know how to use it. And now as a culture, at least in London, I'm finding that we're over relying on it. So what I want to do is show everyone just how easy it is to do this, because I think part of the interesting part about practice is that you can go down the 401 and realize that what we do in London is very different than what happens in Toronto or farther north. And this is a phenomenon that happens all across the board on all different issues, right? So we've already seen that come up today as we listen to the different speakers. And so this is another one that, depending on the jurisdiction you're in, some people don't even know how to do this form that I'm going to show you. And so that is interesting to me, that some jurisdictions have really serious bail plans that could benefit from this and don't know how to do it. So I am going to show you how to do it because I think it's good to see, and I just want to show you just how easy it is. But please do not mistake me showing you this for me trying to do what I did in 2020, which is teach everyone how to over rely on it, okay? But I just want to show you.
Right.
So this is the Recovery Science website. You can Google Recovery Science and find their website quite easily, recoveryscience.ca. So there's GPS monitoring, there's alcohol monitoring. They have a bunch of private services that they used to offer and still do offer some of them. However, you're going to do this guy right here. Click here. And then you're going to go to the intake forms. And on the intake forms, it gives you the eligibility criteria. It tells you all about the program. And then what you want to do is there's submit suitability inquiry or submit installation request. So if you're doing the suitability inquiry, it's about asking if there's an address that they can supervise. The installation request is you've now got your bail order made and you're trying to submit it to them. Technically, most OCJ offices are responsible for this step, but I have come around to realizing that it doesn't hurt to do it yourself, because if your OCJ office clerk forgets to do it, then your guy sits in jail for days before someone realizes that they just didn't send off the documents to GPS monitor. And then they don't end up getting out until the GPS monitor is installed. And so he's been sitting and no one realized, right? So I don't know that we need to do this, but I do it just as a matter of practice. So submit suitability request. So it asks a bunch of questions. It's really easy. Is it for a bail order? Yes. Adults and adult charges only. Yeah, so that's to David's point. Ontario residents, yes. Now, I've had this come up. I had someone who needed GPS monitoring. He lived in Quebec though. He was on the hook. We had to pay for a private company, and Recovery Sciences they've become so big and so large, and their contract with Solgen is now so large that they can no longer offer private monitoring. They just don't have the capacity anymore. So then there's other corporations that if you need, I can send them to you later. Maybe I'll put them in the materials after this, but you can hire them for private. So if you've got someone who's going to be residing outside of Ontario, you might need to be more creative, and you're back to the old days where your client's going to be on the hook to pay for it. Okay. So then the requirement acknowledgements, you're gonna, click off all these after you're sure that you've understood them, read them, and that your client most importantly, your client and a proposed surety perhaps understands them. Oh, thank you. Thank you. And then you're gonna fill out the form. So Cassandra, oh, no, DeMelo is my last name. This is what always happens when you're typing in front of people, right? Let's see if I can type my information correctly. 519-204-7966, and my role. So you'll see a list of roles come up. Defense counsel, interesting, is the only one right now. Why?
.com.
Thanks. Go. So it's gonna ask you who it's for. It's gonna be for a bail order, probably. You don't need to worry about that. Next, level of court, normally OCJ. For me, London. Next. And then you fill out the client's name, et cetera, et cetera. Now, I won't obviously go through all of that. You can figure that out yourself, but the additional residences. So for example, if you've got two proposed sureties and you don't know which one is going to be accepted, you can do both residences, have both pre-checked. Or maybe it's a situation where you're going to have two residences because on the weekdays, surety A is going to monitor, and then on the weekends, he's going to go to the other residence and be monitored by that surety. So anyway, point is you can do multiple residences even. One ankle bracelet can monitor multiple residences, and that's where you fill all that in and off you go to the races. You're going to get an email back that says either suitable or not. I've only on one occasion seen it come back as not suitable, and it was because my client lived in the middle of basically a field. He had a trailer on a field and there was just not enough cell phone tower coverage to monitor it. And once you get that email, you submit that as part of your plan, probably to the OCJ. Bada bing, bada boom, very easy. Okay. I'll move back here.
Mhm.
So as I've already said, for me, I'm probably including that as part of my plan every time because I've been burned enough times on bail review where I'm told that it's not a material change if I just didn't bother to try it the first time. At least that's the take that I get in London. I don't know that I agree with that, but I obviously try to adopt my practice to things that I don't even agree to, but still have to abide by, right? I don't know if others are necessarily going to follow that guidance and offer this, for example, on the low end IPV case, but you can offer it in theory, and then you just have to weigh the risks with the benefits of offering it as defense counsel. With deciding, you get to know your jurists, right? You know your JP, you know whether with this JP it's going to be enough or if it's not. And so you start to learn how to make these calculations in your mind about whether or not you're going to do it. And that's the best advice I can give.
What's the timeline here? Let's say you're interested in it for your client. You think you better consider it. You put this referral through. How long does it take to get an answer back?
That's a good question. So they're very fast. Sometimes I can get an answer within an hour. We've had bail hearings where the same day we were offering monitoring and then we realized, oh, we didn't do the suitability request. And so you can put a note in, I think it's the last page that says any notes and you say urgent bail hearing today. And they get it back to you really fast. But the longest I think I've seen it take is like into the next business day when we ask late the business day before.
Right. And can you comment at all without, revealing anything confidential? What are client experiences like with having these ankle bracelets? Or is it a living hell? Is it tolerable? Like, what's it really like?
Yeah, no, my clients hate it. There's no, they absolutely hate it. There's no sweet talking around that. I've had clients with diabetes who they swell up, their ankles swell up, and it actually causes health concerns, right? I've had clients who hate that they're so easily identifiable as someone who is in trouble with the law and presumed innocent. Right? That's the part that we have to remember is they're presumed innocent. So we've been using this technology for years as sentencing tools, but that's different. That's part of the sentence, right? Is that it's the fact that you're being deterred from doing this by being publicly shamed by wearing the ankle bracelet, but that's different at bail stage,
Mhm.
right?
Mhm.
And so even if I believed in name and shaming as an effective tool of sentencing, I definitely don't believe in that at the bail stage. So yeah, of course, my clients hate it. The important part, and David and I were going to talk about this a little bit too, but I don't want to take up all the points, is the importance of terms. And so making sure that you're not just using boilerplate terms that you don't even know if those are going to be workable for your client. So think about something like an apartment building. Your client deserves to have fresh air. How are you, like, if you've got it so that they can only stay within the confines of their apartment, how are they getting fresh air? So you got to think about that. And you got to include a term that gets them out the door so that they can go for even just a walk outside their door. I'm not talking far, I'm talking 10 meters or whatever, right? But just some fresh air. If they are in a home, they have a backyard, does the JP or the judge want them to be able to access that entire yard? Or do they want it to be even tighter than that? So you really got to think about being creative. So if you're going to suggest it, and if you in fact think that this is probably where the JP is going to go with this because this case calls for it, then do the extra work of really turning your mind to and asking the surety and asking the client about their day-to-day life so that you can include terms that are going to make it as helpful as possible for them to do what they need to do, right? If they're going to go to work, who's got to call in with them, make sure that you understand the program, talk to Recovery Sciences if you never worked with them before, to realize that you have to download an app and the surety has to be there every time to do a little selfie with them and send it in. Like it's freedom is better than being in custody, don't get me wrong, but there's annoyances that come with it, day-to-day annoyances. And if you're going to be on bail for 2 years, like we heard about earlier, that's something that all parties need to be aware of, right? Like this could be your life for every day for the next little while. So the importance of terms can't be understated, and I'm happy to talk about other terms and different terms in that regard later, but hopefully that answers the question.
Like, that's very much so. Okay, so Justice Shawyer, then from the perspective of someone who sits in bail court often, right? What do you think of this? How often should it or should not be used? What criteria are you considering? What do you need to hear from the lawyers to make a proper decision?
When I started off 20 years ago, electronic monitoring wasn't a thing. Back when I started off, detention was the norm and release was the exception. It's now the Supreme Court has come out with Thora, Antic, and all the other cases and reminded us that it's the reverse and that its release is the norm, detention is the exception. So when I look at electronic monitoring, I really do go back to the basic premise about, is it a reasonable condition? Does it apply to the facts? Is it the least onerous set of conditions that is it the least onerous condition I can impose? And so when you take that as your framework, you really have to think that electronic monitoring should only be used in the exceptional set of circumstances. And what I mean by that is you have to take everything into context, because you got to realize when it comes to electronic monitoring, as with most other areas of criminal law, I can pick a decision to justify almost any decision I want. So you have to look at it and say, is it really, really, really necessary? If the person's gone out there and breached 20 times, it might be necessary. But then I had a proposal once in the spring, and they came to a consent and they said, we want electronic monitoring. And I said, well, where's the person live? Well, they're homeless, Your Worship. Okay. So I then said, where is he going to charge this? And they said, oh, he's going to sit at Tim Hortons. And I said, well, hold on a second. First of all, that might be a violation of his constitutional rights, but what about the psychological effect? And they said, well, he doesn't have mental health supports. He doesn't have sound times. And I said, well, I'm not going to impose that because that's not a reasonable condition. And so you have to really go back to, is it really, really necessary? If the person's coming back and this is the third time they've been charged with some type of drug possession offenses, like they're dealing and so on, and it's a high quantity, is it going to be necessary? It very well might be. But if you're coming before the court and the person's homeless and that they don't have any sureties, then it's not going to be useful. But the one thing I want to drive home, if you take nothing else from what we're going to say up here, is electronic monitoring is not to be used as a replacement for a surety.
Well, I'm curious then about the concept of appropriate terms and conditions, right? Because in the Zora decision, the Supreme Court's quite clear, that we should only be using those terms that are reasonable and necessary in the circumstances. What do you recommend then, Cassandra, in a case like this? If it's going to be imposed, what kind of terms are appropriate? What terms are excessive or just setting someone up for failure?
So house arrest is not the necessary starting point, right? You can have GPS monitoring and still be on a curfew. You can have GPS monitoring and have no curfew and no house arrest. It's actually kind of up in the air. We were talking about this as panelists. We got ready for today's panel about whether or not the police are able to use the GPS data without further warrant or some reasonable probable grounds. Like, we don't quite know what the relationship is between police and recovery science. And just the fact that the data exists, does that make it enough for them to access it at any one time? We don't know the answer to that. I wish that we had thought about that sooner, because maybe I would have done some research and called recovery science. But my point is that I don't know that you need to have a term that says that the person's constrained to their house at all. And so maybe the question is that you just want to be able to monitor their whereabouts and know that if you can get the appropriate warrant, let's say warrant is required, if you can get the appropriate warrant as the police officer, you can then get that data to know that whether or not that person was in that location or not, and therefore one more piece of evidence for the Crown, right, and the police. So let's start very broad and let's just start there. Don't necessarily think ankle monitoring means house arrest. Then if you're going to suggest terms that, are really limiting these types of liberty restraints, you're going to think, okay, what about going to from work, going to from picking up kids? Are we going to allow them to be with a surety or without a surety during that, and be really specific in the terms as to whether or not they're allowed to go to, from, or while at work, not with the surety and not at home, right? In terms of the whereabouts of the home itself, the physical location, I've talked about this a bit already, but make sure that you're being really clear. Ask them what kind of residence they live at. Do they have a front porch only? Do they have access to a backyard? If so, make sure that your justice's order is clear that it either does or does not include that, because if it doesn't, like I said, your person's not even getting outside the house, right? Making sure that you have considered, do they have a place to charge the device, and making sure that they understand that they could be charged with a breach of the order if they fail to charge the device. And so that's a condition of the Schedule A, and that's where I really should start, is the Schedule A is kind of your base terms and conditions. And those are the terms that your client has to agree to. And then what I've mentioned is kind of the add-ons, okay? So when recovery science is going to monitor, they either will email you a copy of Schedule A, or I just have one now on my database, and you send that off to the court as well, and your client actually has to sign, or the justice of the peace or the clerk signs on their behalf, that Schedule A. And that, think of it like your probation order, like you've got your standard terms and then you got the add-ons, right? And so make sure your surety and your client understand Schedule A as well.
So David, I mean, from your point of view, does the ministry expect, if this technology is going to be used, that certain terms have to be imposed? Do you have any discretion? I mean, how can Crowns negotiate in this regard?
Yeah, so if electronic monitoring is necessary, and it isn't always necessary, but if it is, I think you'll find that Crowns are looking to tighten up the conditions as much as possible, because it is easier to monitor compliance that way. So you have two types of zones. You have inclusion zones and you have exclusion zones. Exclusion zones are areas that the client is not allowed to enter. So for instance, you might put an exclusion zone around the complainant's address. Make sure you're putting those addresses into Google Maps though, because if a very wide radius is suggested, then it may prevent your client from accessing important social or housing or employment services, and you might want to trim that radius back to say 300 or 200 meters. An inclusion zone is the opposite. It requires your client to remain within a certain area. So if there's a condition of house arrest, then that area might be around the client's place of residence. The ankle monitoring bracelet uses GPS location, so it uses about four satellites to triangulate the precise geolocation of your client. If your client is in an apartment building or surrounded by tall buildings, it's possible that it will not be able to connect with more than one satellite, in which case it will go to the cellular network, which is a little bit less precise. But one of the things you'll see in the document from Recovery Science, and you can tell the court this, is that these devices have been tested in accordance with US government standards of up to 95% confidence level in terms of accuracy. So it's telling the police where the client is within about 3 meters. You have two types of exceptions. So you have a mandatory exception and a tolerated exception. Your mandatory exception would be a situation where you have a condition of house arrest, but your client is allowed to leave their house to go to work, say Monday to Friday. So your client has to be at, say, a warehouse in Mississauga during such and such time, Monday to Friday. And if they're not, then an alert will be sent to Recovery Science. A note for Crowns, if you want to include a mandatory exception, then you have to tell Recovery Science or give the address for the place of employment so that they know to put the boundary around the warehouse, for instance. And then finally, a tolerated exception would be, for instance, a curfew or say house arrest, but the client is allowed to leave the house in the presence of the surety. Then, as Cassandra mentioned, your surety is going to upload a photo or a video to the Recovery Science app saying, we're leaving now, we're together, there's no violation, that's a tolerated exception. So I think in general, Crowns are looking to tighten up the conditions as much as possible. But remember, this is a negotiation and you of course don't need to anchor at your bottom line. You're certainly, as defense lawyers, encouraged to start with, say, a curfew or perhaps no electronic monitoring at all. And I think you'd be very surprised that your negotiation with the Crown may often end up at something a lot more favorable than your bottom line. And of course, the Crowns don't make the final call. So if you don't like where you're getting in your negotiation, then you go to your BATNA, your best alternative to a negotiated agreement, which is the show cause hearing.
Well, that sounds like a lot of fun, Cassandra. So, what do you do when the negotiations come around like this? You won't always maybe get a Crown as fair as David, who simply says, if you don't agree to electronic monitoring, I'm seeking a detention order. What do you do? Is there any negotiation at that point, or are you just between a rock and a hard place? What do you tell the client?
The client instructions rule the day. You're explaining the pros and the cons. You're telling them, here's what happens if you run the bail hearing, the risks and the potential rewards. And here's what happens if we consent, the risks and the potential rewards. And you're also explaining bail variations and how, in theory, maybe with 6 months of good behavior, we can get this loosened or removed or whatever. And then it really has to be the client's risk assessment. They might have a different risk threshold than you would, right? And so maybe they're perfectly content to agree to this because anything is better than where they currently are. Even though you think that you could win a bail hearing without it. And so don't import your risk assessment into the client's decision. It has to be theirs. So have the conversation, get informed consent from them about whether or not they want to agree. And I don't think you have the negotiations with the Crown anymore at that point. I think you just turn to an assessment on the analysis yourself. And then if you're going to run the show cause, you let the JP decide.
Can you and David just step me through? Let's say one of your clients has one of these bracelets and there's a radius restriction, and then they cross the line and they're within 100 meters or 200 meters or whatever it is of where they're not supposed to go. Is it like in the movies when it starts flashing bright red and the police are there in 30 seconds? Or is there some form of mercy from Recovery Science? Do they call the person and say, look, buddy, turn around? How does that work?
Yes, if you have a surety, so this is interesting. You can actually have ankle monitoring without a surety. And so I think the situations that we get alerted to more often are when the surety is getting a phone call because they are detecting a breach of some sort. And so then the surety is calling us freaking out, saying, what do I do? What do we do? And oftentimes the best part is that when you have the surety telling you what the situation is, and they can offer some reasonable explanation for whatever the alert is, that goes a longer way with Recovery Science or with a Crown if ultimately there is a breach than just hearing that same explanation from your client, right? So no, I don't think it's like a red beeping and then all of a sudden police are there. But I do think that you're going to get a breach, and then the surety and maybe the clients, if there's not a surety's, attempt to remedy the situation as fast as possible, give you as much live information as possible about the circumstances surrounding the alleged breach, can then help you later negotiate either a reconsent on essentially the same terms or a consent release with tightening up here or there wherever the problem lied.
Yeah. go ahead.
Oh, I was just
Yeah,
gonna
go-
say, Brock, my understanding is that the device will emit the client's geolocation once per minute. But if the client enters an exclusion zone, for example, the device will go into what's called pursuit mode and start emitting the geolocation once every 15 seconds. And will also emit an audible tone that the client will have to respond to or acknowledge by pressing a button. The recovery signs will say in their information document that it does typically take up to 5 minutes for them to report any breach or non-compliance to the police. And then, of course, it's up to the police to decide how to respond or investigate.
And remember, if I can add, that's the situation where you've got a client who's supposed to be on house arrest or on curfew and is now alleged to have breached. If you're using my example, so when we talked about whether there's a need for a warrant to get that GPS location, we're talking about the example where they're allowed to be out of their house and they're just living their life in that moment. And is the police officer now able to go and get a GPS location of what they're doing in a particular moment? That's what we're unsure of.
And just to pick up on what David said, there's case law out there that says that it takes about a minimum 10 minutes for the police to respond, because you've got the 5-minute lag with recovery science and then probably another 5-minute lag before they can send somebody out. So you got to remember the purpose of electronic monitoring is really psychological, and the restrictions that we place on it, we can tighten them up and we can make them as tight as we want and make sure that they can go outside and so on and so forth. But at the end of the day, you have to remember that the reason that it's put there is to prevent the person from breaching, because psychologically they're going to think that they're being watched at all times. It's kind of like I don't know if anybody knows the panopticon theory about you being in this round jail and people are watching at all times, but you never know when people are watching. That's the idea with electronic monitoring. So I had counsel come into court literally yesterday, and they said, well, we haven't been getting in contact with the client. So I said, okay, you want to tell me why? She said, well, we cut off his ankle monitor. Okay, well, I said, thank you very much. I turned to the ground and she said, I'm not sure what to do. I said, well, I do. I'm going to issue a bench warrant, and it's going to be unendorsed, and the person will have to explain why they should be released again. So that's really what electronic monitoring is there to do. And it only should be used in the most necessary set of circumstances.
What about alternatives? I gotta tell you, I'm thinking of youth court in particular, right? I spent a lot of my career there as a lawyer and sitting there now as a judge. We don't use electronic monitoring in youth court, and I'll talk a bit about that later this afternoon. But what about the fact, that everyone's got a phone and everyone's parent has a phone, or everyone's spouse or one has a phone? Could you not use alternatives rather than this, terribly, arguably stigmatizing device, and say, look, make sure that your son, husband, whoever it is, has the phone on them with the GPS, know your location app on at all times. You have that yourself. You pledge as a surety to monitor, location and whatnot in this way. And in cases maybe where it's not necessary to leapfrog, to the bracelet, is that not an alternative that might be considered when we go down
Yeah.
the table?
Can I start there? So
Yeah.
absolutely. And we prep our sureties sometimes. Half my team is sitting at the front table and I'm looking at them because I know we try to prep our sureties to be like, do you have a Ring camera in your house on the front door? Use that as a tool and say to the JP, listen, I can tell if someone's left my front door and that's the only door that there's access to leave or whatever. And so I'm going to check that and I'll make sure that it alerts me. Or idea with the Find My Phone or Find My Friend, and you just track them that way, right? So I don't know that you need to leapfrog to this, and it's about being creative. It's about thinking outside the box before you jump right to the most onerous thing. And unfortunately, that's sometimes a privileged option because people from lower socioeconomic statuses might not have the technology to do those things. So of course, there's some unfortunate prejudice in that. But if your sureties or your family happen to be in that situation where they can afford it, great.
I mean, David, is that something you would consider, in the appropriate case? Now, there might be some cases you go, no, the risk level here is too high. But other ones you might say, well, maybe we don't need the bracelet. Maybe, we could live with this, if phones and other things are used. A bit more trust maybe in the people involved in the plan of release, less so the technology. I don't know. What's your gut reaction to that?
I think in the right case, it could be appropriate.
Yeah.
And look, I'm always impressed by the apps that they're coming out with. I mean, I'm familiar with Find My iPhone and,
Mhm.
and seeing everyone on the map. And I like to look at all my friends like little Sims. But I was talking to my boss the other day and she was saying, yeah, look, my son, he's right here. He's in a park and I can even press this button and I can listen to what he's saying right now. And I thought, oh, does he know that? So, there's apparently apps now where you can track your kids and listen to what they're saying.
And Brock, I had a bail hearing the other day. It was a contested Crown onus bail hearing. And the surety who was coming forward, she had been a surety before and she had reported a breach, but she was willing to come forward. And literally, instead of electronic monitoring, she told me during her testimony that she put cameras at every entrance to her house. And I said, that's great, but do you have access to something on your phone that lets you watch it? And can you have access to your phone even when you're at work? And she said, yes. And on that basis, I didn't need electronic monitoring. I was satisfied that the person would be monitored properly. And so I think in those set of circumstances, that is a good way around having electronic monitoring, because you got to remember, electronic monitoring is infringing on a person's rights under the Constitution. Whether or not it's necessary becomes a judgment call. And if there's other ways around electronic monitoring, I would emphasize that you try and get your surety to use those.
You don't forget, for those of you who are with us in person, if you want to win one of those books, you got to ask a question, okay? But one observation I'm just going to make is this. We started the day off talking about vulnerable accused persons, right? That's sort of a theme that's animating a lot of these discussions. But for what it is worth, I am very troubled by the idea, you put these bracelets on people and it's just so inherently stigmatizing. And the people who suffer the most from that are the people who are the most desperate to secure any form of release. And of course, are also the ones who may struggle with just following the basic conditions on a day-to-day basis. Some of us, that seems silly. Well, it's not so hard to stay out of a certain radius or do whatever. Many of the people who come before the court that I see, right, are really challenged through no fault of their own and have had very, very difficult lives. And just getting through life on a day-to-day basis can often present difficulties. The idea that I would release them with something that screams to the community, this person's arguably a criminal, and may simply make a breach inevitable, and then obviously almost ensure that the Crown can prove it, feels very dangerous to me, quite frankly. And it's only when it's truly necessary. So for what it is worth, I think that argument is persuasive if you're trying to argue against the use of electronic monitoring and there's an adequate plan of release to the alternative. I appreciate that if it looks like this could be a detention order, anything is better than that from the defense point of view. And not to be, all rainbows and unicorns, there will be cases, unfortunately, where people are simply at such a high risk level. Inevitably, a detention order may come, no matter how benevolent your jurist at the hearing. Does anyone else have a question who's in the room or an observation or anything? We had one that came in online. The question online was just that apparently in some cases, this lawyer has said they've heard the argument that maybe the bracelets don't have any deterrent effect, whatever, and have kind of been dismissed. I don't know, Robert, what do you think about that? I would think they must have some deterrent effect on most people, right? The fear of being caught or it going off.
Well, I think the average person is going to have the psychological deterrence that's required, because we're not seeing case after case of people cutting off their ankle bracelets. So I don't agree with that perspective. And I think as a general deterrence, I think it works. But again, back to your point, only impose it when necessary.
There's
Oh,
actually,
now we got some questions. Perfect.
if I may just
Yeah,
add to that.
yeah.
There's actually an entire plethora of case law that says exactly that concept, that pre-Solgen getting the contract to recovery science, the Crowns used to rely on those cases at the Superior Court level to explain why apparently this is not that great a tool and that it doesn't prevent crime, it can just report crime. My answer to that is that's exactly what police do. But anyways, my concern is now on this side of things, it's a free service. People are able to use it. And you have the same case law being relied upon, even though the technology continues to get better too. Recovery Sciences is constantly putting money into their technology to make it stronger, better, whatever. So you still will see sometimes case law that predates COVID. Be cautious of that to that point.
Yes. Yeah. So we got a question in the back. Yeah.
Sort of a similar to where you were going there, but I've had a lot of instances where they're saying the response I'm getting to the GPS is that it's not serving a deterrent effect. The sureties are doing the monitoring anyway. And I guess what I'm looking for is how do you establish the deterrent effect? Is it inherently built into the fact that they're being monitored? Because there's a lot of occasions you don't want to say, put an affidavit from your client saying I will be deterred by the monitor because you don't want to hear from the guy for whatever reason it may be. So how are you establishing the fact that it would be deterrent for this person?
I wouldn't expect, if it was me hearing the bail hearing, you have to file any kind of affidavit. The argument can just be made, right? This has a deterrent effect. It's up to the court to accept if it's sufficient in this case, if you're concerned, right, on the secondary grounds and something like that is necessary. Would you want to hear anything else, Robert, than that? I mean,
No, I agree. You just have to rely on the general proposition that it acts as a deterrent. And the fact that, as I said before, we're not seeing that many cases of people cutting off their ankle bracelets.
a couple over here.
Hi, I was just wondering, now that Recovery Science is contracting with the government, is there a way of making a Privacy Act request just to find out how many examples there are where people have cut these things off or remove them? I've personally seen that on some of my cases. So I'm just wondering, is there a way of getting some stats on this to see how reliable it is?
I honestly don't know if that would be the route. I'd be curious to know, and David, if you can't answer this, I don't want to put you on the spot to do so. Does the ministry or the Ontario government at large track this kind of information? And is there, some database somewhere of how often the bracelets are being manipulated or altered or something to that effect? Do you know? And if you don't know, I don't expect you to say.
I don't know the answer
Yeah.
to that question, but what I would be doing as a defense lawyer is obtaining the information document from Recovery Science that talks about the devices they're using. They boast about having the best tamper detection devices in the industry with their patented bracelet. And apparently the metal backplate is very hard to remove. So.
And if I can add, Recovery Science also does the sole gen contract for CSO breaches. So if we can trust it to properly monitor a sentence, then the argument is that we can trust it to properly monitor bail.
I'm just going to add that sometimes it gives a false sense of security to the victim. I've personally had those cases, and I've obtained orders from Recovery Science in civil cases to find out about these things. And
I agree, but we got to go back to first principles, which is release is the ordinary course of things in a bail hearing, and detention is the exception. So I understand where you're coming from, and I'm very sympathetic to complainants and people who are victims of crime, but at the same time, we have to look at first principles as the Supreme Court's laid them out.
Maybe we can do maybe one more. Let's see.
I guess one of my questions is pre-COVID, I remember Recovery Science, you needed, sometimes they would have to testify at the bail hearing. And is that being used at all anymore? Is anyone?
No.
No. Okay.
That's exactly what I was talking about pre-COVID, when they used to have to be private, and sometimes your crowns would consent to, I worked with Recovery Science before. I know what they can do. I know what their limitations are. I'm good to not hear from them. Or sometimes they would be difficult almost to try and thwart your attempts at getting bail in a timely fashion and make Recovery Science be there to testify. That is no more. They are just, it's the government's approved provider of the service. So it is just accepted now.
And on that point, please do not come into a bail court and say Recovery Science will approve the person. I can't rely on you as an officer of the court, because I don't know until a Recovery Science sends an email saying, yes, we've approved this address. I can't rely on just you saying they will. I need that. So please come into court with that. And I've been told that they can do these things as quickly as 15 minutes. So you can start the bail hearing, and by the end of the bail hearing, you can have that answer, so long as you've submitted the request before the bail hearing.
Okay, well, look, thank you, everyone. I'm going to bring this panel to a close just so we can set up for the next one. Do we have one more? Okay, one more, sure, yeah.
I just wanted to, I saw Kim Schofield, but she's not in the room, right? Because of course, because she's so creative. She convinced me once that the ankle bracelet was a good idea on the tertiary grounds. And I thought it was really interesting, and it worked because the guy got out. So that's just another way. I don't love the ankle bracelet. It's not something I do very often, but I thought there are arguments. And if she was here, she would make that argument to you, but it is something else to think about.
And there's case law that has applied it on both the secondary and tertiary grounds, and we'll send some of the case law out, I think, in our materials later.
And of course, primary grounds too. I mean, that's obvious, but I just feel like saying it can cover all of the grounds, right?
Okay, look, thank you so much for doing this. It's fantastic. And let's move on to the next one, everyone. Okay, thank you.